Hi, in this brief case law update, I want to talk about a case called Wagner Advocates Conduct Fair Hearing 2015 UK UT 655, and it's a decision of the President, Mr. Justice McCluskey, from the 6th of November this year. It concerns a South African national. He was 73 years old and he'd lived with his British citizen wife in South Africa for most of their lives. 2012, they moved back to Northern Ireland. Wife had some serious health conditions and husband was her main carer. They had a hearing before the First Tier Tribunal and the appeal was dismissed. They complained that they hadn't been subject to a fair hearing, that the judge had prevented them from giving evidence, and they were subject to aggressive, inappropriate questioning from the presenting officer. Mr. Justice McCluskey reviews the questions that were asked, and he finds that, well, probably they didn't anticipate the adversarial nature of the hearing and the sometimes vigorous questions that involves. But Mr. Justice McCluskey takes the opportunity to review the importance of the role of the judge. Have a look at paragraph 8 of the judgment. He refers to the earlier tribunal case of Alu Bank Udi, that's 2015 UK UT 54, and the importance of the appearance of fairness. And he says this: to this I would add that the importance of appearances, impression and perceptions must never be underestimated. Then he says at paragraphs 9 and 10, he says the questions of the presenting officer were inappropriate in this case, but he held that the judge had intervened. The presenting officer challenged the appellant on why the medical practitioner hadn't listed the medications that his wife was on, and there was commentary dressed up as questions, which was totally inappropriate. He says this at paragraph 10, to this I would add that mere comments by representatives under the guise of questioning of a party or witness are not appropriate. He also takes the time to review the principles of fair hearing and fairness at paragraphs 11 and 12, referring to his judgment in Unfairness ENR Sudan 2014 UK UT 105, and he talks about the importance of procedural unfairness, and he counsels against the approach of looking whether the outcome would be the same in any event. He just says there's a single question of whether there was procedural unfairness. He also highlights the difficulty when somebody's alleging unfairness and the importance of advocates doing witness statements and taking verbatim notes of the hearing. Very interesting, mind, is what he does with it. He finds that there's no error of law on this issue, but finds that the judge's treatment of the medical evidence was wrong and sets the determination aside. And then he redetermines it, allowing the appeal. There's a really interesting analysis of 117B factors at paragraph 18. It's only very brief, but it's very interesting how the President deals with it and says, accordingly, the application of Part 5A yields a largely positive outcome for the appellant. And then at paragraph 19, he finds that the Chikwamba principles engaged. He said very properly it forms no part of the... Sorry, it's paragraph 20. Let me read paragraph 20. Given the very particular and highly fact-sensitive nature of this case, it is unsurprising that there is no specific prescription within the Article 8 regime in the immigration rules. Finally, I weigh in the balance the implicit acceptance on the part of the respondent that if the appellant were to return to South Africa, his settlement application would be decided within a period of some 3 months and further would have a positive outcome. This means that the Chikwamba principle is engaged. So it's interesting, we're often told we shouldn't look to whether the entry clearance outcome would succeed, but it was obviously conceded it would succeed and would be very quick, and he finds Chikwamba principles are engaged. So this case is important for a number of reasons. Firstly, there's the procedural sort of fairness points, and the head note is in 3 points, and it says legitimate advocacy does not extend to aggressive questioning or confrontation of a party or witness, and the tribunal should intervene. Comments under the guise of questions are inappropriate, and improper conduct on the part of an advocate which is unchecked and unrestrained can potentially lead to an unfair hearing. I think as advocates we must remember to take a verbatim note of the hearing. We should challenge unfairness as it happens and not stay silent in the hearing, and it may be appropriate to do a witness statement and get somebody else to draft the grounds. I think it's also interesting the application of Part 5A in Article 8, and it's very interesting how the positive outcome that the President finds from it, and then finally his application of the Chikwamba principles in paragraph 20. So have a look at this very interesting judgment from the President. I hope that helps.